Welcome to Bloomberg Law. I'm Lee Pacchia. Joining me now are Andy Dietderich and John J. Jerome. They are with the Restructuring and Bankruptcy Group at law firm Sullivan and Cromwell. Welcome.
Thank you.
Thanks for coming in.
Thank you.
We have so much to discuss today. Let's take it from the top. I guess the biggest story from my vantage point in the bankruptcy world this year was Stern v. Marshall, the huge Supreme Court opinion coming down. It limits bankruptcy judges' ability to decide state court issues. John, you've been practicing bankruptcy law for a long time. Systemic jurisdictional issues have popped up from time to time. Where does this one rank? Where does this decision rank in the scheme of things? Is this all just like the early 80s when we had a jurisdictional crisis of the bankruptcy courts, or is this something to a lesser effect?
Well, I think it's simply an extension of where we've been, and a correct extension of where we have been and where we ought to go. It's always been correct that bankruptcy courts are not normally permitted to make determinations in respect of state law questions. Mm-hmm. And so far as I'm concerned, my reading of Stern v. Marshall is an affirmation of that position. And I know that there are many people out there who think it is going to create a problem for bankruptcy courts performing their function.
Right. And district courts all of a sudden taking on so many more issues.
I just don't see it that way. You may very well find that bankruptcy courts will, as a matter of caution in close questions, make a decision that they are going to hear and report to the district court and send it up to the district court, which could obviate the problem. Kind of curious as to whether or not if the bankruptcy court in Stern v. Marshall had sent the tortious interference question and counterclaim up to the district court on a hearing and reporting mechanism, whether or not that would have worked. Probably not, because I think that, in point of fact, what the judge should have done is deflected jurisdiction because it was a pending case. And it was, bad facts, bad law. It's not bad law, but bad facts. So,
right, Andy, what are you seeing? Is Stern v. Marshall affecting the way that your group is doing business?
No, I don't think so. Our own practice is so M&A focused. I think where it's going to have a relationship is first thing I thought about when I read Stern v. Marshall is actually, ironically, the supply chain for Chrysler. Mm-hmm. When we bought Chrysler, you buy a business out of bankruptcy, so much of the value of these businesses can be in its contractual architecture and its relationships with suppliers and customers, right? And there, we went a long way in the Chrysler process to using the bankruptcy court to resolve all kinds of disputes with suppliers, right? Suppliers would have claims, we'd have counterclaims against the suppliers. And I'm not sure it will change that fundamental approach, but it certainly allows every one of those suppliers or every one of those claimants and those counterparties to add a new 3 pages at the back of their pleading that says, and by the way, we got one other thing to say. This violates Stern v. Marshall. Right. And we'll have to litigate through that and work through that.
So it sounds like it's not necessarily the end of the world.
I don't think so. Not from
not by a long stretch.
It's one of those cases that you have to figure out what it means.
Right.
And the criteria established is one susceptible to all kinds of interpretations.
It sounds like it might be worse for the judges rather than the lawyers.
I think that's probably
I think that's a correct.
There's fewer of them than the lawyers. So.
Correct interpretation. Yeah.
So another big item on the radar: proposed changes to the way venue rules work in bankruptcy. For the last couple of decades, companies have been able to basically file in any jurisdiction in which they had some tie via their place of business. Now they're trying to change it. They just heard testimony from the House Judiciary Committee to amend the rules to require companies to file in their principal place of business. How big a deal is this?
This one, I think, is obviously a bigger change and could have real consequences. The New York City Bar Association, of which the City Bar Association's bankruptcy subcommittee, of which I'm a member, has written a letter laying out its argumentation, and people are back and forth on it. Again, from our practice, I think the biggest detriment to the proposed legislation would be a loss of certainty at some level about the bankruptcy process. Because, you know, it's a federal statute, but every circuit has a different interpretation of many key questions. And New York and Delaware case law, for better or worse, is simply more developed. You know, so if we're buying a company that has a headquarters in Kentucky, and nothing against the Sixth Circuit, I was a Sixth Circuit clerk, right? But if we're buying a company with a headquarters in Kentucky, and we have to look at Sixth Circuit case law on some of the fundamental elements of the bankruptcy code, we're not going to find anything. Right.
John, you've worked with a lot of judges over the years. Is there a concern that if this venue rule change were to go into effect, that it would mean certain judges who are not used to having complicated Chapter 11 cases would suddenly have these types of debtors in their courtroom and not necessarily know how to deal with them as effectively as, say, a judge would in the Southern District of New York or Delaware or maybe Northern District of Texas?
Well, there may be a learning curve problem for some of the judges, but I'm assuming that most, if not all of these judges are very smart guys. What I'm more concerned about is the infrastructure in a particular jurisdiction. I'm not so sure that the clerk's office and the infrastructure in the clerk's office and the U.S. Trustee's office in the district can handle these kinds of mega cases. At least in Delaware and the Southern District of New York, because they've had mega cases for so long, they've geared up and they have all the structure in place. And so I could see the possibility, it's not so much the judges in the district, I see the possibility that the structure in the district could cause delays and problems which could possibly hamper restructuring.
Your practice, of course, focuses heavily on bankruptcy M&A. Tell me a little bit about your practice. That seems a little bit different from just having a bankruptcy group in a law firm.
Yeah, you know, we were a pretty small operation, and we decided pretty early that although bankruptcy was of great personal interest, the existing client base of Sullivan Cromwell was most interested in us really with an M&A capacity. I mean, we see ourselves, for better or worse, as the best M&A firm in the world, right? And it's a very diverse M&A practice, and bankruptcy fundamentally at a strategic level for us is just an extension of that franchise into bankruptcy. We are not interested in doing debtors work traditionally or creditors committee work, and it's interesting because most bankruptcy firms fall on one or the other of those areas or kind of walk the line in between. We kind of just want to buy things and think that's really our sweet spot.
All right. And John, looking forward to, we're almost at the end of 2011, going into 2012. This year we haven't seen a ton of Chapter 11 cases. Do you expect to see more next year?
That's a tough question. I think it depends on what happens to some extent in Europe, and whether or not the calamity in Europe spreads to the United States. But I do think we are going through an historic deleveraging situation, probably more akin to the 30s than the 70s and 80s and 90s. And I think that ultimately, as companies are required to deleverage simply to get on with their businesses, we're going to see more bankruptcy proceedings. And when that's going to occur, I simply don't know. Many of the loan documents are covenant light, and so they may just be able to extend for a year or two or three and not find themselves with the necessity of going into a proceeding. There are going to be a lot of out-of-court workouts at the same time, but when you can't work them out of court, then you have to resort to proceedings. So the short answer is I really can't predict it, but I would guess the next 2 or 3 years, depending on Europe, we could see a lot of proceedings.
All right, gentlemen, let's leave it there. Thank you so much for coming in.
Okay. Happy to be here. Thank you.
Right.
It's Andy Dietderich and John Jerome, both of the restructuring and bankruptcy group at law firm Sullivan Cromwell. If you'd like to learn more about the cases or issues we just discussed, go check out the Bankruptcy Law Report. It's available on BloombergLaw.com. I'm Lee Pacchia. Thanks for watching.